It's my pleasure to be able to introduce my former colleague, Professor Nick Seddon from Canberra. I had the pleasure of working with Nick Seddon in 2000 on the audit review of government contracts. That was a job people may remember where we had to look at the 70 privatisations and public-private partnerships entered into by the Keynote government. And it was a huge job, 750-page report and 20 lawyers, 20 accountants raking through and finding many flaws and problems in those contracts. But more to the point, particularly under Nick's guidance, this document that was produced laid a much more transparent and rational framework for government contracting at that time. And of course, government contracts are ubiquitous these days, and unfortunately not all of them are in the public interest. And fortunately for our talk today, we have one of the undoubted top experts in Australia on government contracts to help us with our analysis. Nick's book, Government Contracts, Federal, State and Local, is the book. He's the man who wrote the book. And you can't go better than that. But really, we do need to understand these things. Both Labor and Liberal in government and in opposition have said much about sovereign risk. They've shown great reluctance to consider rescinding or renegotiating contracts. And we've seen this through the Wonthaggi desalination plant, where opportunities existed because the contractor failed to deliver on the contract, to rescind or renegotiate that. And the governments of both persuasions refused to entertain that on the grounds of what they term sovereign risk. The contractor was allowed to renegotiate the terms of their loans and make significant financial benefit from doing that, but the government side, we were told, couldn't move because of this doctrine of sovereign risk. Now we have the proposition of Labor saying, well, if the Liberal government has signed the contracts for the East-West link before the election, sovereign risk will prevent them from doing anything but going ahead. And sceptics say, is that just a fig leaf for intent to proceed with the project? So we do have to have some good understanding of the issues that Professor Seddon will take us through now. We need to have a good understanding of this question: can governments rescind contracts? Can they renegotiate them? What is this sovereign risk? What options do we have as a community? We could have no better person to guide us on these topics than Nick Seddon. I introduce him now. Thanks, Nick.
Thanks, Bill. Good afternoon, everyone. As I'm sure we're all aware, anyone can break a contract if they want to. The only problem with it is that the other party then has rights against you if you break a contract, and those rights are translated into remedies that the law provides, and the usual remedy for breach of contract is compensation. It's called damages by lawyers. So the starting point is, yes, governments can break contracts, but maybe they'll face a damages claim, but I will now explain that the government does get special treatment in some circumstances. Now, when we're talking about government contracts, most government contracts are relatively small, and they're made under what is called the executive power of government. That is, there isn't any legislation involved. The government simply buys whatever it has to buy just like a human being, just like an individual has the capacity to make contracts, just like an individual or a company, and can just say, right, we want to enter into a contract with you. That's under what's called the executive power. With very large contracts of the type that we're contemplating in this forum, it is quite common to embody the contract in legislation. So, for example, the CityLink contract was embodied in the Melbourne CityLink Act 1995, the Victorian Act, and that means that the contract takes on a slightly different legal aspect because it's embedded in legislation. We'll see a little bit later on that I think we're all making the assumption. Since arriving here this morning, I've asked around is this contract going to be embedded in legislation? My guess is it certainly will be, because it would be an enormous contract. CityLink obviously is a precedent for that sort of thing, and so it will in fact be a legislatively based contract, in which case the last topic that I deal with is the most relevant one. But just to fill you in on the sort of general question of can governments break contracts and why should government get special treatment, there is a dilemma about for governments about contracts, and that is that, as everyone knows, a contract is binding. You're bound by it. That means if you break it, you face the consequences. And at the same time, governments must have a freedom to govern, to change direction. Maybe budgetary priorities have changed. And if you say, well, the government can't move because it's in a contract, you're basically saying that a contract prevents a government from governing. And that dilemma has been resolved by a common law doctrine, which I briefly describe in the paper, called the doctrine of executive necessity. Common law means it's judge-made law. Over the years, it has been recognised in court decisions that government must have the freedom, if necessary, in certain circumstances, to break contracts because of some overriding public interest or a new policy or possibly a reordering of priorities under the budget. That idea that judges recognised was recognised in wartime Britain, where you can understand that the judges would have been sympathetic to the government saying, look, we've got a hell of a job on our hands here conducting the war effort. We cannot be hampered by contracts and be bound by contracts if that means that we haven't got the freedom to make decisions about allocating our resources for the war effort. And so that's how this idea of executive necessity grew up in wartime Britain. It is not confined to that kind of situation, extreme circumstances. It has been recognised by our High Court in Australia as existing in Australia as a part of the law of Australia, the idea that governments may have to break contracts. But there's very little case law on it, and if you ask the question, well, when can a government invoke this special doctrine to enable the government to break a contract, then it's quite difficult to answer that, because there's very little case law. One example that's obviously relevant to the present situation is, could a government break a contract because there's been an election and a new administration has come in? And the answer to that is no. The contract is with the state of Victoria. The state of Victoria is before the election and the state of Victoria is after the election. The fact that there's been an election and a change of administration makes no difference. So the fact that there's been a change of administration in government doesn't justify a new government saying, right, we're going to can that contract. That by itself is not enough. If the new government, on the other hand, had come in on a platform during the election saying, look, we have a different policy to the incumbent government. If you elect us, we're going to shut this project down, and that was the platform on which they got elected, or at least that was one of the planks of the platform, then that would probably be a justification for invoking this doctrine of executive necessity. However, just to demonstrate that the doctrine of executive necessity is very uncertain, not a very safe basis for action, there's better to come soon. A case in Sydney fairly recently, the Commonwealth owns land at Maroubra Head in Sydney, and the Commonwealth has given a licence to the New South Wales Rifle Association to conduct a rifle range there. Now that ties up just about the whole of the land, because they're not 22s, these rifles, these are howitzers. You know, they need 1 kilometre between the shooting and the target, and then they need another kilometre at the other end to where nobody can go because of stray bullets. The Commonwealth has decided now to make over that land to the New South Wales government, to the state of New South Wales, for recreational purposes. And so it needs to shut down the licence agreement that it has with the New South Wales Rifle Association. Well, so far, the Commonwealth has not been able to do that. A case went to court. One of the arguments was the Commonwealth has had a change of policy about the use of this land. That is a sufficient basis for invoking the doctrine of executive necessity. The Commonwealth is entitled to break the contract for the greater good of the public. The judge treated that with some scorn. He referred to my book and said that what I'd said about this doctrine was wrong. I'd made some very tentative suggestions about how the doctrine should operate, and mainly when there's a change of policy. He said, no, that's not right. So that case, where the Commonwealth has failed to shut down a contract on the basis of executive necessity, demonstrates that this doctrine is really very flimsy or shaky. Another possibility, which I don't need to dwell on because I understand these sorts of clauses are not used in Victoria, is you can include a clause in the contract which says that we, the government, can terminate for convenience. The Commonwealth does this all the time. All Commonwealth contracts have got that in it. Contractors object. They say that's not fair because it's one way only. We, the Commonwealth, can terminate for convenience, but you can't. You know, contractors object, but nevertheless they're so keen to do business with the Commonwealth that they wear it. I've had to explain to a contractor that the termination for convenience clause, which does include a component of compensation, is better than its alternative, the doctrine of executive necessity, which doesn't include a component of compensation. You can see that's not an easy thing to do with an angry would-be contractor. So we can put that one aside, and we come to the main one. And this involves a little bit of intricacies of legal stuff. Legislative termination, which would be the only way in which this could be done for this project, assuming that it's a contract that will be embodied in legislation. The idea of legislative termination invokes some fundamental constitutional concepts, and that is that Parliament is supreme, and if Parliament says something through legislation, then so be it. And that idea means that it is possible for Parliament to pass an act which says this contract that was made between the government and whoever is hereby shut down. You wouldn't draft it that way, but that's effectively what the Act says. And so that is the possibility for the situation where there's an election, new government comes in, the contract has already been put in place by legislation, and then the new government has to ponder the possibility of passing more legislation. Parliament can always change an act that it's made before. You can pass a later act and say that doesn't count anymore, or to this extent it doesn't count. They can do anything they like. Perhaps the misinformation that seems to be around about whether governments can shut down contracts, and people saying, no, you can't do that, that might be informed by the fact that 3 jurisdictions in Australia, the Commonwealth and the 2 territories, have constitutional provisions which say, a constitutional provision which says that it is not permissible for the Parliament to make a law that constitutes an acquisition of property other than on just terms. So it's a constitutional protection against a law that constitutes an acquisition of property, a taking away of property without paying proper compensation. That exists. The Commonwealth is constrained by that. Northern Territory, ACT are constrained by that. Now, how on earth can that apply to a contract? Well, lawyers consider the notion of property is much broader than the popular notion of property. We all know what real property is, we all know what goods are and things like that, and maybe even intellectual property. But How can a contract be property? Well, the answer that lawyers give is that it is a type of property that's recognised. It is the right to enforce your rights in court. That's what it is. It's the fact that you've got an enforceable right, which contracts give you, is a type of property. It's called, mysteriously, lawyers like to mystify, it's called a shows in action. That means that if the Parliament made a law which took away contract rights, that could be construed as an acquisition of property. And therefore, if you were the Commonwealth, the Northern Territory or the ACT, you'd have to be careful to make sure that it survived a challenge, because it may infringe that constitutional protection that exists in those three jurisdictions. Now, the good news, maybe, is that that constitutional protection does not exist in the states. There is no just terms provision in the Victorian Constitution, or the New South Wales Constitution, or the Western Australian Constitution, etc. It only exists at Commonwealth level and in the two territories. That means that a state parliament can pass a law that constitutes an acquisition of property other than on just terms, and there's nothing anyone can do about it. Now, if you don't believe me, there is a High Court case on this. There are a number of High Court cases, but the most graphic one, the one that illustrates the proposition most directly, is a case called the Durham Holdings and the State of New South Wales. That went all the way to the High Court. The New South Wales government passed a law which effectively acquired coal assets of companies. The government wanted to acquire coal assets. Why it wanted to do that, I don't know. With hindsight, we might think it wasn't such a good idea. But anyway, that's what it did. And Durham Holdings was a company that was adversely affected by that. The legislation did actually provide for compensation, but it was capped, and Durham said, this is ridiculous, it's not nearly enough. And they took the New South Wales government or the State of New South Wales to the High Court. The High Court dealt with this thing pretty shortly. There'd been precedent cases which had said that state governments have full power, state parliaments have full power to make whatever laws they like. There are some exceptions to that, but we don't need to worry about that. But if you look at the Victorian Constitution, which is the basis on which the Parliament operates, it says the Parliament may make laws for the peace, order and good government of Victoria. It is not limited in the subject matter of what laws can be made, and it is certainly not limited or hampered by the constitutional guarantee that exists at the Commonwealth level and the two territories. And so the High Court in the Durham case looked at this problem, and they said essentially the 4 out of the 5 judges said this is a no-brainer. We've said in the past many times in other cases that states have full power to do whatever they like under their constitutions. This act is perfectly valid. The 5th judge was Michael Kirby, who did not dissent on this occasion. He went along with the majority, but he did give a more thoughtful judgment. He didn't just say it's a no-brainer. He looked at the fundamental constitutional problem that was raised by this case. Is there any limit to the power of a state Parliament in passing laws? Could it just do anything it liked? Kirby looked at that idea, and he said he thought that the High Court would be in a position to say that a state law was unconstitutional if it was what he called an extreme law. He obviously had in mind something like Nazi Germany. He didn't mention Nazi Germany, but that's the sort of thing he had in mind, and he wanted to make it clear that a state parliament didn't have absolutely unfettered rights to make whatever laws it liked. But he then went on to say, in this case, the law that has been made, which takes away the coal assets of Durham, is not an extreme law, therefore it doesn't fall into that category, therefore the law is perfectly valid. So that case is a very important case for answering the question, can governments break contracts? The answer is yes. State governments can break contracts by legislation, by simply legislating through the Parliament. How often has this happened, this type of thing? It's happened quite a lot in Australia. I'll just give you a few examples. Queensland government organised for legislation to go through the Queensland Parliament, which shut down 2 leases, mining leases. There was a special act. It was called the Aurukun Associates Agreement Repeal Act, 2004, and the act singled out the company that had the leases and said that Aluminium Pecini Holdings Proprietary Limited no longer had those leases. As a special act to shut down these 2 leases with this company. And so there was no litigation that followed from that. It was just one of the things that, just an illustration of the fact that governments do this sort of thing. The next one is that the Commonwealth had to acquire territory to make Kakadu National Park. That adversely affected Newcrest Mining, that had mining leases in the area, and they challenged on the basis that this was an acquisition of property other than on just terms. They did succeed, but only just. It was a bare majority of the High Court, and they benefited from that constitutional guarantee in that case. The next one that came along was the Commonwealth Parliament legislated to deal with the Timor Gap and regulating the Timor Gap, and that adversely affected Western Mining exploration permits. They were effectively nullified by the legislation. Western Mining took the Commonwealth all the way up to the High Court, and it did not win the case. And then the last example is a fairly recent one. It's not quite in the same category of a taking of property, but the Commonwealth legislated to effectively destroy intellectual property rights that tobacco companies have in their labelling by saying that you've got to use plain packaging. The tobacco companies took the Commonwealth to the High Court, and they lost. So that just illustrates that it's not unprecedented, it's not uncommon for governments in Australia. We're not talking about third world countries where sovereign risk, the government suddenly appropriates all the oil stuff and that's it, and you've got to live with it. We're talking about in Australia, the idea of the government moving in that sort of way is not uncommon. So that's the legal position, that the state of Victoria, or at least the Parliament of Victoria, could pass an act which effectively shuts down the East-West Link contract even after it's been made. That's one thing, but then we keep hearing this thing about sovereign risk. Sovereign risk is something that it's not a doctrine, it's just a type of risk, and that is when you're dealing with government, governments may have to change direction. They may bring in a new policy. When you look at contracts like CityLink, which go for 35 years, or I remember, Bill and I looked at it when we were doing our inquiry, 35 years, of course sometime in the future something might change and adversely affect this 35-year contract. And so sovereign risk is just a fact of life for anyone who's dealing with government. I mean, it can happen for mundane contracts. The government might decide that it doesn't want to go on buying this product for the next 3 years, even though the contract says that. It wants to shut it down early and move on to another one. And certainly the Commonwealth can do that because of the termination for convenience clause. So sovereign risk is a fact of life for anyone dealing with government. And it's obviously governments recognise it and see that it can be a problem, that people may not be very keen to do business with the government, although that doesn't seem to have proven to be the case. The fact is that companies out there want to beat a path to the government's door. They're so keen to do business with the government. Partnerships Victoria has a website, and I've noticed that back in 2001 there was a document called Guidance Material, Risk Allocation and Contractual Issues, June 2001, chapter 15. It said that at that time, in 2001, it said, we in Victoria recognise that contractors or would-be contractors are worried about sovereign risk. We will do everything we can to make sure that that doesn't happen or that it's absolutely minimised. That was the sort of statement that appeared on the Partnerships Victoria website. I've scoured the website now in 2014 to see if I can find any similar statement, and it has gone. There's no mention of sovereign risk. Now, I don't know whether their search engine wasn't very good, because I put in sovereign risk and it came up blank, and then I went through a few things to see if maybe they got it in there and the search engine hadn't caught it. I may be wrong, that there's absolutely no mention of sovereign risk, but that's, I think, what has happened is that the documents have been modified so as not to mention that embarrassing topic of sovereign risk. Okay, now if a company's negotiating a contract with the government and it's worried about sovereign risk, it could insist on clauses being put into the contract which contemplate that very risk and say, look, if you do something which adversely affects us through legislation or just under the executive power, and then it'll usually spell out there's some sort of compensation mechanism and so on. So you can put clauses into the contract which contemplate the very risk that we're talking about, sovereign risk, but those clauses themselves could be overridden by subsequent legislation. Now, it wouldn't look very good if a government did that. Obviously, there'd have to be a very high justification, if you like, for overriding the very clauses which are there to deal with the thing that's happened, which is sovereign risk has eventuated. But it is still possible because the Parliament can make any law that it wants to. And that's certainly not an extreme law in Michael Kirby's terms. Now, another thing that is mentioned in this context of sovereign risk is that credit rating agencies will take a dim view of Victoria if it shuts down contracts. The Keynote government was very concerned about credit ratings when it came into power. Credit ratings are important for government. You might think, well, what on earth does it matter? Maybe for commercial entities, a AAA is nice, but what does it matter for government? Well, it does matter for government because it does affect the cost of borrowing for government, and governments do borrow a lot. The Keynote government was intent on lifting Victoria's credit rating because it had sunk into the doldrums, and the Keynote government was successful in doing that. And that, I think, Keynote probably would say is one of his great achievements. So it's something that's taken very seriously by the government. What I don't know is how credit rating agencies operate. Do they take a dim view of government shutting down a project when the people, through a democratic process, have effectively said, that's what we want. We don't want that project, and particularly if the next election was conducted on the basis of the Labor saying, if we get into power, whether the contract's in place or not, we're not going ahead with that project. If they'd made that absolutely clear all the way through, then I wouldn't have thought a credit rating agency could then say, well, that's bad management by the government. It's not bad management, it's the democratic process at work. But I don't know how these agencies work. Nick mentioned that they didn't do much of a job. The products that they gave AAA ratings to were what brought down the financial system, and in fact there are cases at the moment going through the courts suing the credit rating agencies for misleading conduct because they gave these wonderful AAA things. But anyway, that's by the way. What I don't know is how they operate in trying to work out whether Victoria should lose its AAA credit rating because some kind of democratic process has taken place, and it is very much so if it's an election, with the election coming up. And the people have decided that maybe it's better for sovereign risk to be invoked when there was fair warning than sovereign insurance should be put in place, which, as I've gathered from talking to people today, that the usual thing behind these public-private partnerships is the justification is you transfer risk to the private party. Well, I understand that's not what is contemplated in this instance, and didn't happen with the desalination plant. So the bogey, if you like, of sovereign risk, it is simply a fact of life in dealing with government. it is something that people can't really complain about, or shouldn't complain about if there's fair warning, such as in an election campaign, that everyone knows that if there's a change of government, then the new government will shut down the contract. Well, as I said, I don't know what the Labor Party's intentions are on that. My job is simply to tell you what the legal position is, and the legal position is a new government, or any government, can shut down a contract by legislation if it wants to. That is, any state government. A Commonwealth or a territory government, we don't need to worry about. They have to do it a little bit more carefully. Thank you.
Thank you very much indeed, Nick. Now I'd like to open it up to questions from the floor. Anyone that would like to?
My question relates to your comments about the state constitutions not having a provision on property rights and compensation for property rights. My recollection is, and I could be wrong too, recollections, that it's the Transfer of Land Act that has got the provision about if property is acquired, there's to be due compensation, and that binds the Crown as well as other parties. So what, in your analysis, does that make, you said if it's in the Constitution, there's a great problem, a la those High Court decisions about the Federal Constitution, but if it's in a Transfer of Land Act, and it's property about land, not necessarily specific contracts for construction, does your judgment about these things, are they any different?
No, that particular piece of legislation is about the government having to compulsorily acquire land for a project like this. And that act is there, and it says if the government does that, then the government has to pay compensation. And there's a mechanism, if there's a disagreement, there's an arbitration type mechanism to sort that all out. That is simply an act of Parliament. And it doesn't touch on what we're talking about, because it's simply about the process of compulsory acquisition of land, and that's all. And it could be overridden to the extent that it's necessary, maybe. It probably, I don't think it would be necessary, but supposing it was necessary to modify that act because of shutting down this project, they can do it. They can do that. It's just another act. It's not the same as a constitutional thing which can't be altered, or effectively can't be altered, but an act can be by a later act.
I was just going to say, when members of Parliament talk about sovereign risk, either in Parliament or in the media, and they say you can't change these contracts once they're signed because of sovereign risk, are they sort of missing some words there? Like,
yes, they are.
Sovereign risk that you will make for other people dealing with you?
What they should say is, if we change this, if we shut this down, it will be perceived as an example of sovereign risk and we will get a bad reputation. That's what they should say. Sovereign risk it's not a legal doctrine, it's just an idea, it's just a category of risk. It's a category of risk which is, if you deal with government, then governments aren't necessarily as sure to deal with as maybe BHP Billiton is, but even that doesn't count, because everybody breaks contracts, but governments break contracts because they're permitted to in certain circumstances, as I've described. And so that's regarded as sovereign risk. It's a special type of risk in dealing with government. And normally it's not, you don't think of it within Australia. You think of it when, if an Australian company went out to some country out there, third world, and the dictator takes over and says, we're going to acquire all your stuff. That kind of thing is regarded as sovereign risk. Couldn't happen in Australia. But sovereign risk does encompass what we're talking about here, but it's nothing special about it. It is simply part and parcel of what governments can do. And I've given you a number of examples where governments have, they haven't used sovereign risk. They have done things which could be labelled sovereign risk, but in fact at the time when Kakadu was being put together, nobody used that language. It was something that had to be done. It was in fact in implementing an international obligation that the Commonwealth had. So sovereign risk is, I think you're right, it's sort of thrown about without properly using that expression.
We're very nice people in Victoria, so we would never deal with anyone other than on just terms when we're required to by the Constitution or not. How would the assessment of damages for a contractor whose contract was revoked be done? I think we understand there's money expended on the proposal. There will be some money expended post the contract. The predictions for the project are that it won't make money. The $2 billion won't have been expended like the diesel plant. So how, if we wanted to deal on just terms, would we assess what a contractor was reasonably owed?
The answer to that is that there are very well worked out rules about how to assess contract damages, where you say, how much does this person get because that person broke the contract? That measure of damages, I would suggest, is not the benchmark for dealing with this type of situation. And in fact, the Commonwealth Termination for Convenience Clause does not, normally you can claim lost prospective profits. If you can prove that you would have made a profit and you've been deprived of that because of this other person's broken the contract, you can claim that under common law damages. But the Commonwealth's Termination for Convenience Clause specifically says, we'll pay you for what you've done, we'll pay you to the extent that you can show us that you've wasted money because of the early termination of the contract, that the onus is on you to establish that, and we will not pay you for lost future profits. So that's not a bad measure. What's in the Commonwealth Termination for Convenience Clause isn't a bad measure for answering your question. In this particular instance, if let's assume a new government comes in, they shut down the contract very quickly, the amount of damage will not be very great, as long as you rule out the future profits business. Things are at the very early stage. Yes, of course, there will have been some resources, legal fees, of course, all of that stuff. But in fact, I understand that that there is a form of tender process going on at the moment, and they're being paid to develop their tenders. Is that my understanding? In which case, all of that is taken care of. They can't say, oh, we've wasted all this money preparing our tender, because that's been paid for by the government, so that's out of the way. They will have incurred some other expenses in setting up and getting ready, etc. But if things are chopped fairly early in the piece, then they're obviously not going to start incurring the heavy expenses of actually constructing and so on. So my guess is that the compensation could be kept within reasonable bounds. If you make that decision, we will do the right thing and pay compensation, but they don't have to do that at all if they legislate. But you said you're nice in Victoria. The New South Wales government did compensate the coal companies, but it was capped. It said so in the legislation, and the coal company said that's just ridiculous, it's not nearly enough. So there's an example of where the government sort of did the right thing, but then it wasn't quite right enough. And my guess is that you'd have to, as a matter of policy, if you decided to shut the contract down, you'd have to say, we'll give you some compensation, but we're certainly not going to give you the equivalent of contract damages, which would include the profits stretching 30 years into the future, discounted to now as a lump sum.
Thank you. My name is Greg. I'm from Melbourne Community Against the Tunnel. I guess that part of my question has already been answered. It is a case of what is the effect on whether a government can make the contract. If first of all, the drawing up and signing of the contract is hurried for the express purpose of binding successor governments, that if the opposition gives fair warning prior, not just the election, but prior to the signing of the contract, and third, if there's been little expenditure between the signing of the contract and its cancellation. And I understand that I think you've pretty well covered the third aspect of my question.
So I didn't quite get what the first two aspects were.
The first aspect was if the drawing up and signing of the contract is hurried for the express purpose of the government binding its successors. Yeah. And second, if the opposition gives fair warning, not only prior to the election, but prior to the signing of the contract.
My answer to that is that it's not so much a legal thing, because the legal side is the new government can shut down the contract. Okay? Now, if it wants to occupy the moral high ground, it will say, we gave you fair warning before the contract was signed that we didn't. This is not our policy, and then we're now going to implement what we said, which is to shut it down. Both of those things were, you had fair warning of that, and it's really more of a political or perception matter that those 2 points that you raise are about. The legal one is straightforward; they can do it. Obviously, doing that is going to be very controversial. There's going to be a certain amount of flack, but that flack can be fended off by that strategy that you've talked about.
But not passing legislation to deny any compensation. Then would it be preferable to measure the loss by breach of contract, or would it be, as an alternative, could the government take the shares in the joint venture company held by the joint venture participants and compulsorily acquire them, so that the risk that the joint venture company suffers in other respects over the prospective 30-year period then gets factored into the assessment of compensation on the acquisition of those joint venture company shares?
Yes, maybe. It could do that by legislation or by agreement. You can always agree to change a contract. With a legislative contract, you'd have to look to the legislation to see what the mechanisms are for doing that. Usually they don't require a new Act of Parliament to just make adjustments to the contract. But I mean, my view about compensation is that so long as there have been warnings and everyone knew what the risk was, that the idea of paying, I mean, if there is a clause in there that says you get full loss of profit compensation over representing loss of profits for 30 years, and that would be a very badly drafted contract for the government's point of view if they did that. But let's assume that's there. That can be overridden. Now, you've said let's assume they're not going to override that bit of it. Well, my view is they may have to, because otherwise they'll be stuck with a very, very heavy financial burden.
Sophie.
You were talking about the Keynote government and them coming into a AAA rating. It's absolutely clear that the Keynote government did renegotiate several very large contracts, including the gas contracts and the contracts related to the Alcoa, and achieved a AAA rating. So it is definitely possible to significantly renegotiate or even cancel or terminate contracts which have been long-standing and very profitable to certain companies and still get a AAA rating. Keynote did in fact do that. Yeah. My other question is about or comment is about the way the legislation could work. In the CityLink contract, there is a clause which states that the contract had to be presented to the Parliament and that it had to be agreed to, or if it was voted against by both houses of Parliament within 6 days of having been presented to the Parliament, it could be rescinded and considered not to have been agreed to.
Yes.
That may be relevant in the case of the Eastlink, or the East-West that's coming up, because it may well be that the signatures of the contracts will occur in a period when the Parliament is not sitting, and therefore the contract can't be presented to the Parliament until after the election?
They'd have to make some sort of preliminary contract in that situation. Usually with these statutory contracts, the contract itself is actually a schedule to the Act. So in other words, you've got to pass the Act first, then the parties grab that schedule and sign it just for, I mean, they don't need to sign it really, but they do because it's a nice ceremony and so forth. So if the legislation hasn't been passed and they enter into a preliminary agreement along the lines of this is binding on us, they'd have to say in that preliminary agreement, but all bets are off if it doesn't go through Parliament. That's what they'd have to say. If they said this is binding on us and we will guarantee that it gets through Parliament, that's something that a government cannot do by contract. It cannot say we guarantee to pass legislation. Well, it can say it, but it's meaningless. That's very well established that a government cannot bind itself to make a particular law in the future, because that's what Parliament does, and the executive government is not Parliament, and it cannot bind the Parliament. The Parliament is supreme.
My name's Kathleen Molson. I'm the Greens candidate for Richmond in the state election, so one of the areas impacted on particularly by the tunnel. I had a question of clarification and then a broader question. The question of clarification is in terms of, I guess, helping people understand sovereign risk as something other than some hand grenade that's going to blow up if we do the wrong thing. Is it right to say that one of the points with this particular case is the threshold, in a sense, is so high that you're not going to lead to a domino effect, in that we're talking about something that has been opposed, there's been significant public debate. If a party was to signal prior, or parties signal prior to election that if they're in a decision-making position, they wouldn't keep the contract. That is such an extreme threshold that you couldn't get over it for most things.
Yeah, I agree with you. I think that's a fair point, and it seems to me that the best way of presenting this to the people and to the credit rating agencies is to make that all very explicit. And you're right, it's a one-off example. It's not some deep malaise. The Victoria can't ever be trusted, etc. I agree with you. I think that's a fair point. And that depends a bit on how the message is got across. If the government was minded to say, we're going to do the right thing and we'll not only compensate you for what you've expended, but we'll compensate you for lost future profits as well, one answer to that might be, you simply don't know that they would have made a profit. Experience shows that in these projects, not only do they not make a profit, but the companies go bust and have to be rescued by the government, as with the cross-city tunnel in Sydney and the Queensland tunnel. So the business about lost future profits is very speculative, and one argument might be, if we shut this down, we're actually saving you money.
It's appropriate for governments to act in that way, where they are giving private companies a kind of carte blanche guarantee that they will insure them against any kind of loss, while at the same time claiming a competitive process is necessary in order to gain the best possible profits or the best possible outcomes.
My answer to that is that the theory behind contracting out and public-private partnerships, as I understand it, and I'm not an expert on public administration, the theory is that they do it better and they take the risk. And of course they then make a profit. And that means the government is free of risk, theoretically. But it doesn't work that way. If the project falls over, who has to step in? The government. It's too big to fail. Have we heard that somewhere before? The rhetoric about this and the theoreticians, the public administration theoreticians, I don't think they've thought the thing through. It's something I talk about a little bit in the first chapter of the book, that the people who advocate the use of contract by government don't understand what contracts are about. I'm not talking about lawyers, I'm talking about, you know, those people in universities who say, yes, contracting is the way to go. They don't understand about contracts because we all know that contracts are difficult, they may not work, people will break them, you've got to administer them, they're a pain in the neck. It's much easier to get public servants to do things than to get contractors to do things, but that's I'm getting a bit out of the thing, because that's obviously not applicable to these types of contracts. But the fact is that there is rhetoric, bullshit, and so on. And that's really, I think, all I can say.
Thank you very much indeed.
And perhaps just, I do know about contract, and it's a very difficult vehicle for government to use. It does not solve all problems, and that's been demonstrated time and time and time again. They've got to use contracts for this kind of thing, but the idea of this partnership, that's not really the case, and the fact that they're supposed to be transferring risk to the private sector, that's not really the case, and so on. It's very problematic.
As Professor Seddon said at the outset, all contracts can be broken, and the worst possible outcome for a new state government might be that it ends up paying some compensation if it abandoned the east-west tunnel. That might not be a bad outcome, but as Nick said, there are grounds for arguing that a new state government might avoid paying any compensation whatsoever. I think, particularly if it announced its intention to rescind the contracts during its election campaign, and I think that's a message which needs to be understood by a lot more people. Nick, on behalf of everyone here, I'd like to thank you very, very much for your presentation, coming down from Canberra, and not just providing the presentation here, but providing the whole day, because he's been in transit for a fair amount of that time. So thank you very much indeed. I think it's been a fantastic forum. I've been very pleased.